Hey guys, welcome to the Trademark Like a Boss show. I'm Radiance Harris, founder and managing attorney of Radiance IP Law, and I help emerging businesses protect, monetize, and grow profitable brands with trademarks. And today I'm going to be talking about this false news surrounding the White Lives Matter trademark. It's quite baffling to me how such false news about these two Black men owning the White Lives Matter trademark has like completely infiltrated the media circuit. I mean, CNN, all of these big media outlets reporting this trademark news that is 100% false. And it's quite shocking that none of these outlets did their due diligence, consulted with perhaps a trademark attorney expert to get their opinion, to support the news story before blowing it up. So if you're not familiar with what is going on in terms of the White Lives Matter trademark, in early October, Kanye West, was parading around in a White Lives Matter shirt. Everyone's outraged. A few weeks later, the news is reporting that these two Black men own the White Lives Matter trademark. They apparently purchased the rights from someone, and now they have a pending intent to use trademark application for the mark. The media is reporting this as them actually owning the mark, which is wrong. So there are a few things that are wrong with this whole scenario. One, the fact that these two Black men said that they purchased the rights from someone who wants to remain anonymous. First off, if they did purchase anything from this anonymous seller, they were basically bamboozled because they didn't purchase anything, especially if the guy didn't have a trademark registration, didn't appear to have a business in selling a White Lives Matter clothing brand. So essentially, whoever they supposedly purchased these trademark rights from bamboozled them, and they have purchased nothing. So right now, the two Black men that they are posting about all throughout media do have an intent to use trademark application for White Lives Matter, covering a wide range of clothing. So this was filed sometime in October. And so what that essentially does, so what a pending intent to use application. So there are two ways you can essentially file a US trademark application. You can file it based on current use, meaning you've been using the trademark commercially in commerce and you have evidence of that use to support the application, or you can file based on an intent to use. When you file an application based on an intent to use, it allows you to stake your claim to future use of the mark. So it allows you to establish the priority date. So meaning the date that your application is filed, you do have priority, like meaning you're in line for potential use of the mark should you move forward. At the time of filing the application, however, you do have to have a bona fide intention to use the mark. So you can't just file a trademark application to prevent others from using it if you don't actually have a bona fide intention to use the mark. So here, from what I'm gathering from the news articles, is that these men don't have a bona fide intention to use the mark. They have just been they locked it down because they want to be able to sell it to other organizations to prevent the mark from getting into the wrong hands. But that is not how trademarks work. So there are essentially two ways that you can establish trademark rights. You can establish it by actually using the mark commercially in commerce. So you're actually selling a product or service. And then, more importantly, securing a US federal trademark registration. So a US federal trademark registration indicates actual exclusive legal rights and ownership in the trademark. And so when you don't have that, you only have a minimum of common law trademark rights in the geographic region that you're using the mark, assuming you are actually using the trademark to sell a product or service. In this case, I haven't seen anything. I haven't heard of any reportings that these men are actually using the trademark, meaning selling a White Lives Matter clothing brand. I'm hearing that they own this mark and they're holding it down to be able to sell it, but that is not how trademarks work. One, they ended up buying the trademark reportedly from someone who didn't have any trademark rights to begin with. And so now they have a pending trademark application. That does not mean that they have trademark ownership. So they are not able to sell or transfer the rights to any trademark until they, one, start using it. So meaning they start promoting a White Lives Matter clothing brand, which probably is not likely. And then two, they secure a US federal trademark registration certificate. And so I'm just totally shocked and appalled that nobody in the media has tried to verify the facts of this. They've just literally taken this information and ran, And so right now, no one owns the White Lives Matter trademark yet. They have a pending trademark application, and that's it. Kanye West doesn't own it because, as far as I know, he just slapped it on the front of a shirt. I don't think he's starting a White Lives Matter clothing brand. And so it does not establish trademark rights. So basically, if you are having a shirt and you have something plastered on the front, like a design or something, that does not equate to trademark rights. It's just a design on the front of the shirt. For it to be considered trademark rights for a clothing brand, you essentially need to have it on the inside tag of the shirt or a hang tag to indicate that it's a White Lives Matter clothing brand. So if you have a Fruit of the Loom shirt and you just slapping stuff on the front, that is not a clothing brand or clothing line. What makes it that is just like when you go to a store and you'll buy a Under Armour shirt or a Nike shirt, and you see on the inside tag that there's a Nike or Under Armour emblem. That is what creates trademark rights, is when it's an actual clothing brand. And so that is what would be required here, is that these men would need to be selling a clothing brand, a White Lives Matter clothing brand, securing a trademark registration for that, because they wouldn't be able to actually get a trademark registration until they can actually prove commercial use of it. So that's the one hurdle. They have a pending application that was just filed. I mean, the process takes about 14 months, so probably won't know how everything ends up panning out until the end of next year sometime, maybe into early 2024. But they would need to provide evidence of actual trademark use before you can get a trademark registration. And that's for anyone who files an intent to use application. And so the benefit to filing an intent to use application is that you're able to kind of I would say you can kind of look at it as putting a deposit down on a mark. So it's your way of put a deposit on it. You're holding your spot in line with the US Patent and Trademark Office, so that if anyone files after you, they would be blocked by your prior pending application. But as far as actually establishing trademark ownership, it does not function in that way. It just allows you to get your place in line. So as you're getting your business affairs in order, getting the mark used, getting the clothing brand together, you can have that peace of mind and knowing that no one is going to beat you to filing first with the US Patent and Trademark Office. So that is the primary benefit of the intent to use. So it is very beneficial to utilize an intent to use trademark application, because you have essentially up to 2.5, 3 years plus to actually commence use of that trademark. So there are a lot of benefits to doing it, but the application has to be filed with the actual intention to eventually use it. So the bona fide intention to use it. I haven't, based on the numerous news reportings and articles, I haven't heard anything to indicate that these men are actually going to be starting a White Lives Matter clothing brand. So, right now, the news that's being put out there is unfortunately inaccurate, does not appropriately, indicate how trademark rights work. These men do not have trademark ownership in White Lives Matter. And again, I'm just like, I don't know. It's just so crazy to me how much this is blown up for it to be false. So when it comes to trademark matters, I would definitely recommend, speaking to a trademark expert, not like a general business attorney, not someone who may have filed their application last week or not, any of that. I would recommend speaking to an actual trademark expert who can really educate you on how the trademark process works and what trademark rights you actually have. I understand that these men, work with an attorney to file their application. It's unfortunate that they don't really understand what rights they have right now, which is really, they don't have anything. They don't have any rights. And so it's unfortunate that they don't understand what they have, and they're promoting this false information, and then the media is actually just like running with it. Like I've read things at the highest places. So just to like reiterate what I've shared today, no one owns the White Lives Matter trademark yet. A pending intent to use trademark application does not establish trademark ownership. There are only two ways to establish actual legal ownership in a trademark, and that is one, through actually commercially using the trademark in connection with a product or service. So you're actively promoting the mark in connection with a product or service in the marketplace. And then the second way is securing a U.S. federal trademark registration from the U.S. Patent and Trademark Office. Those are the only two ways to establish trademark ownership, none of which are available or evident in this situation. But I am excited to see how this all unfolds. I do hope that the media does eventually correct this, and that the real information is out there, because it's unfortunate that this is out there and it's totally false. So if you are interested in securing trademark ownership, so actual legal ownership in the marks that you are using in the marketplace, or eventually using in the marketplace. So if there's something you're planning to launch within the next 6 months to a year, you should absolutely pursue the U.S. federal trademark registration process to make sure that you have actual legal ownership in that brand that you are building in the marketplace. Because right now, if you don't have a U.S. federal trademark registration from the U.S. Patent and Trademark Office, you do not legally own the mark, the logo, the tagline, the product or service names, the event name, whatever it is, podcast name, whatever it is that you're putting out there and promoting and using your hard-earned dollars to, promote and get your name and brand out there. You don't own it until you actually have established trademark ownership through use and a U.S. federal trademark registration. So I would encourage you to do that. If you haven't already, definitely schedule a trademark strategy call with me where we can walk through and identify what trademarks you have, what you should prioritize. This month, I'm offering a promotional code, Save 100, for $100 off a trademark strategy call with me. So I hope that you found this episode useful and it's provided some clarity to you as to how exactly trademark ownership rights work, and unfortunately the sad news that they're promoting about the White Lives Matter trademark. That is in fact false news. So thank you guys for tuning in today with me, and I look forward to seeing you next time. Bye.